We will now provide some quiet time for reflection before our program begins. I'm Mark Elliott. I am Executive Director of Floridians for Alternatives to the Death Penalty. And what you just saw was an example of the quiet time that begins each Quaker meeting. We would like to thank the Quaker Southeastern Yearly Meeting for hosting this important event, and the Quaker Committee for Ministry on Racism, and the Peace and Social Concerns Committee for sponsoring this forum. My name is Mark Elliott. I'm Executive Director, again, of Floridians for Alternatives to the Death Penalty. And there's a saying that the more you know about the death penalty, the less you like it. That was true for me, and it's true for just about everybody that with an open mind finds out about this program of on the death penalty. FADP is a statewide organization that represents thousands of people and dozens of organizations in the state of Florida united to end the death penalty here. Our network includes murder victims' family members, law enforcement professionals, exonerated death row survivors, a lot of people with direct experience, families of the incarcerated. We work to end executions and reduce death sentencing in our state. What is effective is highlighting the death penalty's problems, and there's many. And today's focus is racial bias. There's also wrongful convictions, executions of the seriously mentally ill, and the failure of the death penalty to meet the critical needs of victims and families. Just a few housekeeping notes. We will have time for Q&A after the session. Please stay muted throughout the presentation and direct your questions in the chat. We're so fortunate today and honored to have three panelists who have perspectives on the death penalty, either through really knowing a lot about it and doing the research and having the accurate information on it, to having direct experience by being an innocent person on death row for a crime that someone else committed. Our first speaker is Ngozi Ndulue, and she is Senior Director of Research and Special Projects at the Death Penalty Information Center. Ms. Ndulue's legal career is focused on the intersection of racial justice and the criminal legal system. She received her law degree from Yale, and from 2016 to 2018, Ngozi served as Senior Director of Criminal Justice Programs at the National NAACP. Ngozi's current work focuses on deepening the public's understanding of the origins, functioning, and impact of the death penalty. Ngozi is the lead author of the Death Penalty Information Center's September 2020 report, Enduring Injustice, the persistence of racial discrimination in the U.S. death penalty. Our second panelist is Dr. Frank R. Baumgartner. He holds the Richard J. Richardson Distinguished Professorship in Political Science at the University of North Carolina, Chapel Hill. His research includes significant work in the area of capital punishment, including such issues as trends over time, public opinion, geographic patterns, innocence, and other matters. He is the co-author of The Decline of the Death Penalty and the Discovery of Innocence, and Deadly Justice, a statistical portrait of the death penalty. Our final panelist is my friend and colleague, Herman Lindsay, who was wrongfully convicted and sent to Florida's death row in 2006. In 2009, he was exonerated by unanimous verdict of the Florida Supreme Court and became the 135th person to be exonerated from death row in the United States. I think the current number may be 185, unless it's gone up since I checked. He was also the 23rd person to be exonerated from Florida's death row, and that number is now 30 and growing. He is the board secretary, Witness to Innocence, a group by, for, and made up of death row exonerees, exonerated death row survivors, and he is on the board of Floridians for Alternatives to the Death Penalty. He is also an ambassador for Represent Justice. He hosts the online show Cruel Justice, which if you haven't seen it, you really should check that out. You can find out more about it on our website or Witness to Innocence site. And Herman speaks across the United States and internationally. So first, I would like to introduce Ngozi Ndulue. We're so fortunate and happy to have her here.
Thank you so much. It's wonderful to be here with you this evening. And I'm always excited to talk about the death penalty into kind of as the Death Penalty Information Center's mission is to just deepen our understanding of not just the raw numbers of what's happening with the death penalty, but the real context and background of that. And I think that we were able to do this with the Enduring Injustice report. So I'm just going to give you a really quick overview of the report. It's available on our website. I'll put a link in the chat when the presentation's over. But let me share my screen here. So I'll do a quick presentation. So we put together the Enduring Injustice report, and we actually published it in September of last year. And I think that, as everyone knows, that last year was a moment of deep contemplation of just how serious racial injustice is in the United States and around the world. But for us at the Death Penalty Information Center, you really can't talk about the death penalty without talking about racial injustice. It's one of the real givens that it affects every piece of a death penalty case. So this report had been in the works for several years. I've been at the Death Penalty Information Center for about 3 years. And even before I came, there were plans for this report to be written and published. So the timing of the release was great because people had already started thinking about these issues. And I thought that this was an opportunity for us to really deepen our thinking about something that we know about, but don't necessarily always put together the puzzle pieces. So what we wanted to do is to kind of trace the history of race and the death penalty, starting with the colonial period in the United States and coming up to today. Then thinking about the modern death penalty, look at how race affects every single stage from arrest to execution. And that it has a role that we don't always acknowledge in cases today. And then thinking about this more broadly, there is a connection between the racial injustice in the modern death penalty, with mass incarceration, with movements to end police violence, with movements for prosecutorial reform. And we wanted to make that connection explicit. So we'll start with the history here. So race has always mattered when it came to who was getting the death penalty and for what crimes. We knew that there were different capital crimes for white people and Black people. Sometimes there were distinctions between enslaved Black people and those who were free. There's disproportionate use of capital punishment against Black defendants. We saw this definitely in the South, but even in the North, where we would see more capital punishment being used in northern colonies against Black defendants, and more torturous and gruesome executions. So at times where the standard was hanging, where you'd see, gibbeting and tarring and feathering and all sorts of kind of types of spectacle that could be attached to executions of Black defendants. Not everyone, but more frequently. And then in states with enslaved people, there was the use of executions as this tool of oppression explicitly. The idea that some crimes, particularly crimes against masters, crimes against white people, were seen as kind of petite rebellions, that there was this idea that you were kind of stamping out the possibility for slave rebellions by using the death penalty. And I'm talking a lot in terms of Black and white, but we also know, and that is a fundamental part of our history and our history of slavery that was kind of enshrined in our United States Constitution even. But we also need to think about effects on Indigenous populations. There was a continual battle between sovereignty and the way that the criminal legal system was used to stamp out fights for Native American sovereignty, and ways that the executions were being used against Indigenous people across the United States. This is a depiction of the largest mass execution in US history, and this is in 1862, 38 men were executed after the US Dakota War. So in the history of this execution also says a lot about this idea that executions were being used as a result of conflicts that at their heart had concerns of sovereignty involved. And in other circumstances, you saw Indigenous leaders who were executed saying, wait, so what about the white people that were fighting as well? The US, this execution, this mass execution was supposed to be the result of offenses against civilians. And Abraham Lincoln was specifically involved in ensuring that, reviewing pardons, because this was done under the authority of the federal government. So there were a number of people granted clemency. There were supposed to be more than 300 people executed at first, but there was also this political theme that came into this about, if we seem too lenient, what problems does that raise? And there was this political balancing act, which if folks were paying attention to, the federal executions last year, we continue to see, and we've seen this throughout time with the death penalty in general. And so if we're going past the Civil War, we know that there was an increase in legal lynching, or in extra legal lynchings, where there was violence and kind of these racial terror lynchings that have been documented by historians, and most recently the Equal Justice Initiative, Equal Justice, EJI, who has documented more than 2,000 racial terror lynchings between 1865 and 1876, and more than 4,000 between 1877 and 1950. And when we're talking about lynchings, we can't really understand what was happening with lynchings without talking about legal executions. So the common conception of lynchings is this kind of unbridled mob that really was not really connected to the judicial system or the criminal legal system. But there was also an interplay here where at times you would have lynchings that would have the kind of blessings, either official or the wink and nod blessings of elected officials in towns. You would also have towns that would say, we really don't want the press coverage that a lynching would give us. So we can assure you that there will be a swift execution. Justice will be served. So don't lynch the person. We've got this. The judicial system has got this. We would also see discussions about abolishing the death penalty, where the idea that, death penalty abolition is risky, because if we abolish the death penalty, there's not going to be this outlet for public outrage. And we might have these lynchings, which again could cause us some embarrassment in international circles, especially as anti-lynching campaigns started to take place. That sign that you see in the picture there hung in front of the NAACP's national headquarters in New York every time there was a lynching. And the NAACP itself was founded for general, civil rights concerns, but specifically because of episodes of mass violence and lynching, and kind of to head up some of these anti-lynching campaigns. So that the tie between legal executions and lynchings stronger than you would think just on a casual understanding of what lynchings were. So even as lynchings were decreasing, we're seeing executions increasing, and we're also seeing executions very much continuing to be tied to race. And because of this, civil rights groups like the NAACP Legal Defense and Education Fund were taking a growing interest in death penalty cases. And there were some very famous death penalty cases that got international interest, and they were often the case of a Black man who was, falsely accused or accused on very flimsy evidence of the rape of a white woman. And those kind of cases that got a lot of international attention, the Scottsboro Boys. We can talk about the Groveland Four in Florida. The great book on that is The Devil in the Grove by Gilbert King. But with these cases, there was a mounting understanding that the death penalty was a civil rights issue, and there needed to be a broader focus on what was going on with the death penalty and how it was being used to perpetuate racial oppression, to support Jim Crow and the social stratification there, and to punish entire groups of people for this idea of bucking the social order. So the Groveland Four case is a great example where there was some economic instability. There were questions about whether the people in the citrus groves were going to get the cheap Black labor that they expected. And there was a sense that the Black community needed to, be taken down a peg. And this was part of the genesis of that case. We see that in other cases of mass violence. You saw in the Tulsa massacre that was commemorated this year is another example of that. There are examples throughout the country. And when we were talking about those race disparities, we also were talking about race disparities, particularly with this crime of rape, which at the time was punishable by death, even if there was no specific murder. And we saw that throughout the country, the vast majority of people who were executed for rape were Black, more than 80%. And we also know that throughout the history of the country, no white man was ever executed for the rape of a Black woman that was not also accompanied by a murder. So we see the issues that we're going to see in the modern death penalty. One about these kind of societal, fears, anger, use of the criminal legal system to force this kind of enforce the social stratification, the stereotype of the criminality of Black men. This idea of that Black women are not deserving of protection, and that question about the victims and how much the victims are going to affect what punishment happens. So just getting to the modern era, that for us is starting in 1972 with Furman versus Georgia, where the capital punishment was suspended, and going on to Gregg, where it was new statutes were passed, including in Florida, and the capital punishment resumed. And we see that the same issues arrive. We didn't end up with a post-racial death penalty in this modern era. So the same places that we were having huge numbers of lynching are the same areas that we're having the higher numbers of executions. We're seeing these questions about lynching and the long shadow of lynching that still is coming up as we're discussing the death penalty. This is actually from a Texas case where someone was arrested for killing a police officer in November of 2016. And we have a judge who in the Facebook comment says, it's time for a tree and a rope. And we have comments like that throughout. So this question about the tie between this legalized execution and extra legal lynching was recognized in, back in the early 1900s. It was recognized when we were even talking about whether the death penalty is constitutional in the time of the modern death penalty. There is one of the justices' opinions, Justice Stewart mentions the fact that if we don't have a forum for retribution, we're opening the doors to mob violence, self-help, and basic lynching, right? So this idea that we need the death penalty because it channels some form of our communal rage, which is very much racialized, is still here. And then I think that talks about the numbers speak for themselves too, where we see that as far as who is being executed for the murder of whom, we see that the victims in the cases for which people have been executed are overwhelmingly white. And that is not because most murder victims are white. It's about half and half, but it is because of the cases where we have decided that this is the most serious case, right? Because supposedly the death penalty is supposed to be about the worst of the worst crimes. And we basically have decided that killing a white person is a worse crime than killing a Black person. And I'm sure Professor Baumgartner will speak more about that because he has research that's very much directly on point. But knowing that this is the case, knowing that this is the criminal legal system that we have right now, the Supreme Court has decided, it's decided in 1987 that we can't really do anything about that. Some states have enacted racial justice acts. We saw how that happened in North Carolina. Unfortunately, too many people were granted relief and the legislature changed, so they stopped that type of relief. But we actually just recently saw California pass a racial justice act. And there are several, we can talk about this in questions, but there are all sorts of ways that race, both implicit bias, overt bias, the way that the system is constructed as far as jury selection, the potential for discrimination in jury selection are going to affect these figures. But the issues that, decades and centuries into our experiments with the death penalty, we see the same patterns, we see the same issues, and we see the continuing racial injustice to this day. So I will stop there. Sharing here.
Thank you, Ms. Indeloy. And that was incredibly informative and eye-opening. I mean, I had some aha moments watching that, and it really, you highlighted the link between the the legacy of lynching, the high use of the high number of lynchings in Florida, and the high rate of lynching in Florida have transformed and have made possible the state of Florida it being a high use state today. I mean, it never really changed. It was always about that. So thank you very much. Now I'd like to invite Dr. Frank Baumgartner to further discuss the racial biases present in Florida's criminal legal system.
Thank you so much for having me tonight. I wanted to first acknowledge Herman Lindsay and thank him for being here. And I'm going to give some comments that speak to some statistical patterns, but I know that Herman will have some comments that are of a very different nature. So I just want to recognize his presence and thank him for being here. And I want to thank the organizers, and it's a pleasure to follow my friend Ngozi, and I'm going to try to follow up a little bit on what she has said. I want to preface my remarks by saying oftentimes it's difficult to think about how to speak about the death penalty to people who support the death penalty, assuming that those of you who are with us tonight might be opponents to the death penalty. Oftentimes that comes from a religious or philosophical perspective that your interlocutor might not share. And so I've done a lot of research about the statistical patterns of how the death penalty actually works. And my advice is, if you're talking to somebody who might be philosophically, morally, or religiously predisposed to support the death penalty, I'm going to give you some ideas about some facts or considerations that you might throw into the conversation that would cause them to rethink their support of the death penalty without having to go to the trouble of rethinking their entire philosophical, moral, or religious perspective on life. And to do that, I want to think about Justice Thurgood Marshall. And he's the person who first, maybe not first, but he famously said that if people knew very much about the death penalty, they wouldn't support it. And he said that he wasn't really that interested in public opinion surveys about the death penalty because he thought that most people don't know much about the death penalty. And if they knew as much about it as he did, they wouldn't support it. So let me go through a few kind of talking points. First is deterrence. Deterrence is a joke. Deterrence has not been demonstrated. Many ideologically involved people on both the anti-death penalty side and the pro-death penalty side have come up with conflicting findings with regards to deterrence. But I want you to step back from the statistical analysis about deterrence and think about the psychological process that's implied in the theory of deterrence. That is, the person on the verge of a homicidal act is going to stop himself and think about whether this state has a death penalty. Not only does this state have the death penalty, which is a fact he or she may or may not know, but do they actually catch their criminal suspects? Do they sentence them to death at a high rate? And do they carry out the executions at a high rate? Those are all things that are assumed to be fully known in the mind of the homicidal actor at the time of the crime. And I would just submit to you that that is stupid. That's about the dumbest thing you could ever imagine. And yet people have a theory of deterrence. The National Academy of Science has evaluated the literature on deterrence, and they have said that we shouldn't pay attention to it. Second argument is whether the human institutions are designed to be perfect. And the answer is no, they're not. And they can't be made to be perfect. The death penalty has an incredible number of fail-safes. And yet there have been 185 people sentenced to death in the modern time since 1972, and 30 people just in Florida who've been sentenced to death like Herman, who were innocent of the crime. So that is a rate of error that is unacceptable, I think, on anybody's terms. And also, even for people who support the death penalty, they would not support, for the most part, executing people who did not commit the crime. We actually have executed quite a number of people who did not commit the crime because they were the getaway driver or they were involved under the theory of felony murder. So they did not actually pull the trigger, but they were involved in the crime. I believe that, and Gose could correct me if I'm wrong, but I believe there's been 16 people executed in the United States where there was no allegation that they actually murdered anybody. The next thing I want to mention is the rate at which the solemn words, "You are hereby sentenced by the state of X to be executed by lethal injection. May God have mercy on your soul." Those turn out to be false statements. 70% of the time, death sentences are overturned on appeal. So these are not necessarily cases where the person is found to be innocent, but they're found to be not properly sentenced to death. And typically they're resentenced to a term of life in prison or to some lesser term, depending on the state and the time. 70% reversal of these solemnly imposed death sentences should send shivers down anybody's spine. It's something that people are not aware. Fewer than 20% of people sentenced to death are actually executed. So those are facts that suggest that the system just does not work as people think it might work. Next thing I want to mention, we don't use the death penalty much, considering the number of homicides that we suffer. The United States, since 1972, 76, when we developed the modern system of the death penalty, approximately speaking, since that date, there's been roughly 1 million homicides in our country. We routinely have about 20,000 homicides per year across the United States. Now, all of those crimes are not death eligible, but all of them do involve a person who's lost their life. So they're all homicides. They all create a gap in some family. And out of those 1 million homicides that we've collectively suffered as a nation since the mid-1970s, we've had about 8,000 death sentences and then about 1,400 executions. 1,400 executions out of 1 million homicides is a very, very low rate of use of the death penalty. And even 8,000 death sentences out of 1 million is also a very, very low rate. Then the question is, are those few people selected for capital punishment the most worthy defendants? That is, those who committed the most heinous crimes, or those who have the least remorse and the worst attitude towards their crimes? And the answer is, we don't know, but there's no reason to believe that it works very well. And there's many reasons to believe that it works according to many flaws. The biggest flaw is race. In Florida, 56% of homicide victims in the modern era have been white, of all homicide victims. But when we look at the cases where the homicide led to the execution of the offender, 72% of the people of the victims were white. Blacks represent in Florida 43% of all the homicide victims, almost half. But they're just 17% of the victims in cases that led to execution. Not a single white person has been executed in the state of Florida for killing a black person. high status people are more likely to see their killers face the death penalty than lower status people, that is economic status. Vulnerability of the defendant comes in many characteristics, the possibility that they might have mental illness, their mental capacity, their level of poverty versus wealth, their race, their age, their gender, being male, whether they have good legal representation or poor legal representation. The death penalty typically in Florida as elsewhere is reserved not for the worst of the worst, but for the most vulnerable, the most mentally ill, the person least able to mount a robust defense, and so forth. Death penalty is very capricious and arbitrary along several factors. The first is geography. Certain counties develop the habit of imposing the death penalty, and other counties simply don't do so. And this is true in Florida as well as in other states. There's a time-based arbitrariness to it. Crimes that happened in 1995, 2000, in that area around the mid to late 1990s are perhaps 5 times more likely to lead to a death sentence than similar crimes that happened in 2010, 2015, or 2020. There's no logical reason to believe that we should support a system that's so capricious with regards to the year or the decade in which the crime occurred. This state and county level variation in the use of the death penalty, and I should mention that the state of Florida is one of only 3 states, Texas, Florida, and California, that have sentenced 1,000 people to death in the period since 1972. So there is tremendous variability state by state, and then within states as well, county by county, huge variability in how often different geographical units use the death penalty, controlling for how many homicides they have. One of the things that predicts this variation based on geography is public opinion. And what matters about public opinion is not necessarily what you think, it's actually racial resentment. The degree to which the white members of the public have resentful attitudes towards Blacks is a significant predictor of the use of the death penalty at the state level. A second factor that makes a difference and is connected to the first is historical lynchings. Those counties across America that had more lynchings back in the Jim Crow period in the 1920s and 1930s still today are more likely to use the death penalty. The last thing I want to mention is the cost of the death penalty. Many people think that it must obviously be cheaper to put someone to death than to pay for their food and meals and living and medical expenses over what could be many, many decades of life on death row. But I would mention that New Jersey spent over $100 million on its death penalty system before it abolished the death penalty in 2007. And New Jersey carried out 1 execution. So the price for that state was $100 million for carrying out a single execution. So there are any number of practical conundrums associated with the death penalty. And I'll stop with that short list and be happy to follow up and question and answer or provide some resources for this. But I think that it's shocking when people learn about the facts associated with how our country has actually implemented the death penalty system. If it applied to middle-class people, there would be outrage, but it doesn't apply to middle-class individuals. So there isn't as much outrage as we might expect. And those many people who support the death penalty support a theory or a picture of the death penalty that's not an accurate picture. So I think it is important for people to understand how it really works. And it's very ugly. Thank you.
Thank you, Dr. Frank Baumgartner. We've just heard from 2 experts that have studied racism in our criminal legal system extensively. I invite you now to listen to our final speaker, who has lived the experience of an innocent person falsely accused, wrongfully convicted, and sentenced to death for a crime someone else committed. My friend and colleague, Herman Lindsay.
Thank you, Mark. First of all, I thank everybody for coming here today. The information that you just received from both prior speakers are dead on the point, money. So, I'm going to go into telling you what happened to me so you can see those points that they made as it pertains to prosecute one of these death penalty cases and being considered the worst of the worst. And back in 1994, a robbery at a pawn shop happened where the person inside got, I think it was a female, white female. She got tied up in the chair and shot in the head, executioner style. In 1994, when it first happened, it was a group of people that was running around robbing pawn shops and things like that. And my god brother was considered part of the group. Because my god brother usually be around me, I actually was questioned, not as an aspect as being a actual suspect, but actually being a person that can help with information as far as putting a light on what happened. When I spoke to them in '94, I couldn't tell them much, but I told them what little that I did know, and nothing happened. I even took a lie detector test and nothing happened. 12 years later, the detectives who was working the case for 12 years from the beginning of the case decided to retire. When he retired, another detective took over who was trying to make great rank into the actual department. And when he came and asked to speak to me, I had no problem speaking to him. And when I decided to speak to him, he was asking me questions about something that happened 12 years ago, and I just couldn't remember exactly what was going on or what went on and things like that. So instead of saying something different, I would just say, I'm not sure. I don't remember. And many of us can't even remember what we did 2 or 3 days ago, alone what happened something 30 years ago, unless it was something significant there, like the greatest birthday party you ever been to. So with that being said, when he left me, I thought we was okay, and the next thing I know, he went to Fort Lauderdale, Broward County, and got in a grand jury indictment and charged me with first-degree premeditated murder, first-degree felony murder. But the thing about it, when he got the grand jury indictment, he put me and my god brother together in the case and presented it to the grand jury. He brought in all the evidence that he could use towards my god brother. And with that, majority of it couldn't be used in my trial and should not even be used or considered again a grand jury indictment on me. The grand jury granted the indictment on board myself and Mr. Lorraine. However, they tried us in 2 different courtrooms and actually charged us separately for the case, such as he was charged with murder over here as a sole person without me listed as a co-defendant, and I was charged over here without being listed as a co-defendant. And when they first arrested me, I thought maybe, you know, hey, I've been in the system before, 21 days, 30 days, I go home. You know, the charges be dropped, you know, they'll know they got a mistake. But it didn't work like that. So I went to court. When I realized they was actually charging me was when I went to court and they appointed me 2 attorneys. And that was during the arrangement. I met with the attorneys immediately after they was appointed within a couple of days, and the process started. And I was going to court like every 2 months. And after a couple of months, I was like, I can't sit in here for this. I didn't do this. I didn't do this. I asked my attorney to file for a motion for speedy trial, demand for speedy trial, which was granted. When the motion for speedy trial was granted, they decided to move forward with trial. This was after maybe 6, 7 months being incarcerated. And my attorney thought I was crazy, but I was like, I didn't do this. Why should I be sitting here? And normally the people that's fighting murder charges stay in there 2, 3 years. And I'm like, I don't want to be in here no 2 to 3 years fighting for something I didn't do. When it was granted, I can remember my first day in trial. We was getting ready to select jury, which a process I didn't understand, and I'm not quite fully understandable of the process now. What's this? I understand what a strike is like that, but I don't know the strategy of picking jurors, and how I didn't know the strategy of how they pick juries and how they single out certain people that qualifies. But the worst thing about it is that our courtroom got very slim quick because they asked the question, do you believe in the death penalty? Because you impose the death penalty. And when people said no, they was automatically rejected out of there. So our courtrooms jumped from maybe 100 selection down to maybe 30, 40 selections. So now my selection of jury went very slim. But I could remember the state attorney coming there to me and saying, listen, Herman. And he spoke to me. He didn't speak to my attorney. He spoke to me. And he said, listen, Herman, we need to resolve this right now. I know my boss, who was Michael Satz at the time, who was one of the worst state attorneys of all times at Broward County. I'm willing to give you 3 years in prison in exchange for manslaughter. Now, this is, I want to point this out because I realized this later as I began speaking, that they was seeking the death penalty on me, but yet he was willing to do a plea bargain with me for 3 years, and I'm supposed to be one of the worst of the worst. So it seems to me that it wasn't about the justice. It wasn't about the person that deserved the death penalty. It was about obtaining a conviction. When I looked at him, I was like, I didn't do this. I'm not going to accept a plea on something I didn't do. I'm sorry. So my guilt phase attorney was an alcoholic. He was giving me coffee with a little shot in during trial. I wasn't complaining at that time, but yeah, it was a time. My penalty phase attorney, which I think was the most amazing attorney in the world, he tackled everything that he could tackle. In fact, I think he was so good too. The judge did a motion before we started trial that did a statement before we started trial that he could not handle anything in the guilt phase. The guilt phase attorney had to handle the case in the guilt phase. He was strictly the penalty phase. He got to stick to penalty phase. And I think the judge intentionally limited him to that because she see that he was capable of proving my innocent, or, you know, this, the conviction wouldn't even happen. That's what I believe. Trial began. The first piece of evidence was the victim picture, the worst picture of the crime scene, placed on a big projector screen in front of the jury, what my lawyer called inflaming the jury. And while it sat there for 2.5 hours while the medical examiner explained the cause of death, a single gunshot to the head. The second piece of evidence was a pawn shot slip. When in 1994, they asked me, have I ever been there? I told them the truth. I said I had been there. And in fact, I pawned my Sega game, which is like a PlayStation now, to the pawn shop, and I used the alias name because I had a warrant for tickets. They came up, and they would have never even found the pawn slip had I not been honest. And they came and used it and say, hey, look, he was there staking out the place. And the pawn slip was weighed 2 months more prior to this incident even happening. You know, so the next piece of evidence they used against me was my ex-wife. My ex-wife was on the stand, and I guess she gave a statement to the effect that she seen me and Lori walk out the house that day with some jewelry. Now, you know, blue Royal Crown bag or purple, which I'm not sure which one. But either way, her and the state beginning to get an argument. When they got into an argument, the state moved to impeach her because she wasn't saying exactly what the state had, I guess, coached her to say. And he said, you need to tell the truth. She said, okay, you want me to tell the truth? The truth is, one, only reason I gave that statement was because the detective was threatening to take away my kids, threatening to arrest me, threatening my grandmother, and always harassing me at my job. In fact, I told y'all I didn't know anything about the case, and the detective basically told me what to say. And this is on transcript. The next piece of evidence was a guy who in 1994 was the prime suspect of the case. He was, in fact, he was considered the gunman. As they did the investigation over the years, he was always saying he didn't know anything about that, about this crime. When when 2005 came around, 2005 came around, the new detective went and talked to him. Apparently they worked out a deal. And when they worked out a deal, he all of a sudden said, hey, I remember I was in the holding cell with this guy, Herman Lindsay, and he told me that he was, he committed this crime and that he had to offer all witnesses. Now, mind you, this guy is locked up for being part of that group I talked about earlier of robbing pawn shops. And they also had this guy on camera where he went to one of the clerks. The clerks gave him the money and he still shot the clerks right point blank. And they have this on video. And yet his testimony was gold. With that evidence that I just spoke to, no fingerprints, no eyewitnesses, no DNA, I was found guilty of first-degree premeditated murder, first-degree felony murder. And the part that get me the worst is that we gave special jury instructions where the jury was asked the question, check the box if you believe Herman Lindsay was the actual gunman. Nobody ever said I had a gun. Nobody ever said I actually committed the crime. Yet the jury checked that box and said that I was the actual killer. I was found guilty, and with an 8-4 vote, I was sent to sentenced to death. And I would never forget that day because I remember when the judge say, we, the people of the state of Florida, now hereby sentence you to die by lethal injection. I was numb. I was numb from the time I got found guilty. In fact, when I went and found guilty and I was walking out, I could remember the state attorney telling me, don't worry about it, Herman, you'll be back. You'll definitely be back on this case. So, I kind of felt confident, but I still was dazed. I don't know how this happened. And when I went to death row, I didn't believe the same system that actually convicted me would be the same system that would free me. I see people on death row 18, 20 years going back and forth to court and, appeals and litigations back and forth. I mean, and if you look at the majority of people that has been exonerated, their cases took 15, 18, 22, 35 years before they even actually be found of, innocent. And here it is, the state, like for instance, the state of Florida tried to put in, I forgot the name of the bill, but the bill would speed up the execution where the execution would be in 5 years. You know how many innocent people the state of Florida would have killed in that time? It would have been seriously ridiculous. And when we talk about racism, and I'm sure Mark can later back me up on this. I remember we at FADP, we used to go to every little town at the churches and the schools and we used to speak. And one of the things we used to say is that Florida has never killed a white person for killing a black person. We used to say that all the time. And I can remember back, I think it was 16 or 17, we was in a committee hearing and we mentioned that. Shortly after, the governor decided to execute Mark Ase in 2017 for killing a black person. And that was the first case out of the whole state of Florida. And that's because we was able to, because I feel we was able to constantly say, how prejudiced it is that, Florida never killed a white person for a black case. But the death penalty, and I'm gonna bring it to an end because I know we have time, but I want people to understand that most state attorneys aren't using the death penalty for justice. They are using the death penalty to polish their record, to actually try to get more favor for those that on the side that's for death penalty, or the people in the offices that in the legislature that believe in the death penalty and they want to be cool with them. I think that the death penalty is abused and misused, and I must say I do believe the death penalty us here in Florida has killed an innocent person. I mean, we got to look at the history of the death penalty way back when we talk about lynching. That's when the execution started, way back in lynching. They just modernized it by bringing the electric chair and then the lethal injection. But it's been going on for years and years, and it's always been mainly meant for the blacks. It's been always mainly meant for the blacks. And the thing about it, like I say, we have family members of victims have fought, like Suzanne Bossler, I forgot the woman in Jacksonville, but they fought the state attorneys, and while they was fighting the state attorney to stop the defendant from getting the death penalty, they end up getting threatened. They end up getting, spoken bad about and things like that, and their life get a little a fight. Why would the victim family have to fight if they feel like the death penalty is not justice and the state attorney pushing for it? And with that being said, I would like to bring this to an end because I want to make sure everybody has time for questions. The death penalty in the United States, you know, we talk about how China and other countries just dehumanize people by executing them. I think we're doing the same thing in a modern way, using the gurney. You know, I've been close to that room, that very room. In fact, when you first get on death row, they house you in G-Wing. And when G-Wing sits like this, the death chamber door sits like a T to it. And when you're going in, they make sure they let you know you're coming in this door, but when you leave, you're gonna leave out the back door of that wing there. And that's all I have to say. And thank you for tuning in.
Thank you, Herman. Thank you, Herman. Thank you for sharing your story. Is a way that only someone that's been through what you have can do. It's powerful witness to the truth of what the system does and what it means personally to you. And I know it's tough for you to talk about this, and it's really, we don't really understand what it could have felt like and what it would be like. But we're a little closer to being able to a little bit imagine what that situation is like, being innocent, expecting you're going to be, you know, of course they're not going to find me guilty. I didn't do anything. There's no evidence. And then you're on death row and what that means. Thank you so much for that. We're going to move to some Q&A. And let's see. I'm going to take this moment to say that it was brought to my attention that in the chat room, one of our board members, Ralph Wright Jr., who's also exonerated death row Florida survivor, he's number 27, is tuned in, and we appreciate that, Ron. And anyway, Ron, just so you know, was a decorated war veteran. He was career military, former Orange County, Florida deputy sheriff, had a sterling record. I don't think he ever been written up for anything. And yet when that spotlight fell on him, he was railroaded and sent to death for a crime he didn't commit. So this happens a lot in Florida. We had 30 exonerated death row survivors in Florida. So the QA, let's see.
We've got one question to get us started.
Oh, okay.
So I'll just jump in here. Hi, everyone. I'm Allison with FADP. Mr. Lindsay talked about how the prosecutor stacked the jury against him. Ms. Ndulue, can you elaborate on the ways jury selection is prejudicial for people facing a capital trial?
Sure. I think there's so many parts about Herman's story that really paint the picture of some systemic failures in the capital punishment system. So when we think about the jury selection, there are so many ways that, one, juries get selected in ways that stack the jury in favor of conviction, and two, that diversity in juries get decreased throughout, which also actually stacks the jury in favor of conviction and death sentences. So when we talk about, I'll start from the big picture about like who actually gets called for jury service. The question about which actual lists do you pull from to get people on jury? Do you actually include just registered voters? We know all the issues around voter registration and racial disparities there. Do you pull from the DMV list? I don't know in Florida specifically where you're pulling from, but that also changes determines who is even in the pool to be called for jury duty. But then when we get to calling people for jury duty, there are so many kind of hurdles to actually getting on the jury. First one is about strikes for cause. Herman talked about people being death qualified. So basically, if a case is charged as a death penalty case, and gets to the jury selection stage, jurors have to say that they are willing to impose, and there's like a whole legal test. So it's not just like, oh, I don't like the death penalty, but they have to say that they're kind of willing to be on a capital jury, knowing that they would have to make a choice about between kind of a life sentence or death sentence, right? And so just in that stage, that really skews who's on the jury. You get rid of all the people who say that they have such strong objections to the death penalty that they could never impose it. And what you end up with is you end up getting rid of disproportionately people of color. You also end up with people who are more likely to convict, who are more willing to convict even on kind of ambiguous evidence on the jury pool. Curtis Flowers' case, if folks know, out of Mississippi, where he was tried 6 times and is now an exoneree. He got relief from the United States Supreme Court because of jury discrimination issues. But of those 6 trials, 2 of them were non-capital. It's ridiculous how many times this man was tried for something he didn't do. But on those 2 non-capital cases, it was mistrial. There's a hung jury. But it was the capital cases where he got the convictions. And the reason is because you end up with jurors who are more willing to convict on shakier evidence. So then you have the death qualification, you wash out folks. You also have these things called peremptory strikes, which is basically that both sides can strike based on any reason. But the Supreme Court has said, Batson versus Kentucky, that it cannot be a discriminatory reason based on race and gender is involved there on a protected membership in a protected class, right? So sure, you get to use any reason, but you can't be discriminating based on race. Clearly, that has not stopped prosecutors from trying to get people of color off of juries. And we've seen some very flimsy excuses. Her clothes were too bright. Her nails were too long. She has a son the same age as the defendant when it's a Black woman, but if it was a white woman who had the son, same thing, no problems, right? So there has been, it's been demonstrated throughout that this peremptory strikes are very much a way that prosecutors can discriminate, and that the existing protections against discrimination at that stage are not very strong. We even had a recent case where the prosecutor on their list had marked who was Black, and the judge had said, oh, they were marking who was Black so they would protect themselves if ever somebody argued that they were discriminating in jury selection. It wasn't the fact that they were marking who was Black so they can strike every single Black person off the jury. So we know that jury discrimination is rampant at that stage. We've seen some efforts to reform the way that peremptory strikes happen. In Washington State, the court adopted a general rule that really allowed the judge to be skeptical of some of the decisions on some of the reasons given for striking juries, and to recognize that some of those reasons reflect at the very least implicit bias, but very well could be explicit bias. And California just also revised their racial justice. They had Racial Justice Act, and at the same time jury selection reform. And Arizona, I think, is getting rid of peremptory strikes altogether. So all sorts of opportunities for discrimination, all sorts of ways that that's going to skew the jury, not just in their racial demographics of the jury are going to affect how open they are to mitigation, how long they deliberate. A more diverse jury deliberates longer, is more open for mitigation, and is able to kind of take that information in. So just by skewing the racial demographics, you're skewing the jury, but you're also selecting for folks who are more prone to conviction, who believes more strongly in retribution, who also have more anti-Black bias. There are good studies on that as well.
Thank you, Ngozi. Thank you all for your questions. Al, do we have another question?
Yes, hold on one second. Let me get to my phone here. This is from our audience. I'd like to hear what Herman thinks of his experience talking to Florida legislators. Have you been surprised? What has your experience been?
I hope no legislators are on this call, but it's been a very great experience dealing with the legislators. I have a lot of legislators that has become friends with me and trusted, and they tell me straight up what it is. But the hurtful thing about it is that in our legislation, they are so divided. Not only just Republicans and Democrats, but they have their own little groups inside too. And sometimes, it be the Speaker of the House who has the power. And the most hurting thing to me that was said to me out of the legislation was we were seeking compensation, and we needed we needed to address all the issues instead of just patching the bill up like a band-aid, and the representative told me and say, I would do that, but X and X wouldn't entertain the bill, and this person is the person that determines whether your bill's gonna meet the committee, whether your bill will be. So if you try to push a bill in there and the bill is right, it's where it's supposed to be, and the person who's over the committees decide, no, we're not going to entertain that, then he can blackball all your other bills also. So that makes legislators kind of afraid to push for what they're supposed to push for, and only push for a little bit at a time. And I think that was the worst experience of and hurting feeling, because the compensation bill, you have to go back to trial, and you have to prove that you are actually innocent to receive compensation in the state of Florida. First, it was the problem of prior conviction, but we got that out, the Clean Hands Act out. But now we have the problem, you have to go back to the trial court and prove you're actually innocent. And most trial judges don't even know what that motion would be or how that process would be. Ron was here, he could tell you he went through that. But it would be much easier if the state attorney would just admit in the case that they got it wrong. But I just want to say one thing about the jury thing, that the jury question that came up, and I'll make it real brief. I think the biggest problem with our jury selections here in the state of Florida, in our jury, I think the state attorney has a method to pick those that really don't want to be there, because our juries are undereducated too long. Some of them don't even know what a reasonable doubt is, and a lot of them don't want to be there. A lot of them want to make excuses to leave, and through the jury, if you pick for the jury, you're forced to be in a place that you don't want to be. So I think that plays also a part of our failure in our jury selection. And I think that is very important that we have these events, and we at FADP and Witness Innocence strongly believe that educating everyone that we can about the miscarriage of justice is the greatest thing, because you never know who may become a potential jurors, and how they need to understand how important it is for them to pay attention and even ask questions if it's something that they don't understand. You don't have to agree with the others, and I know you get tired of being there, but you got to also think about you're determining somebody's life. And how would you feel if you was on a jury and you choose to say that I was guilty, in fact, that check the box that I was the gunman, and then turn around and find out I wasn't even the one?
Thank you, Herman. Al, I think we have time for one or two more questions.
Yeah, we'll have two more questions before we have our announcement section. This one is from Sheila. Can Professor Baumgartner tell us if he has seen the attitude of students regarding the death penalty changing over time? And you are on mute, so hold on.
Just with regards to students, I would say that I don't know every student in America, but the ones that take my classes don't tend to be supporters of the death penalty. So I've never seen a big change over time in the support of the death penalty. And I think that among college students, it's relatively low support on average, and it has been for a long time. So I can't speak from any personal experience about a shift that I've seen. I can certainly say that nationwide, there's been a dramatic shift from support for tough on crime policies of all types, reaching a maximum in about the Bill Clinton period. 1995 was the maximum period of public support for punitive policies, including the death penalty. And since about the mid to late 1990s, nationwide, the trends have been dramatically against the death penalty, and also against mass incarceration, moving away from the harsher punishments that were more popular in the 1980s and 90s.
I'd just like to chime in real quick if I could. What we've seen in Florida is somewhat mirrored nationally, and that is a recent poll of registered voters in Florida found that 62% preferred some form of life imprisonment over the death penalty for someone convicted of murder. And that number is increasing all the time. We feel that as people find out about the mistakes that are made, about the racial bias, about how the program actually works, who's being executed and why, and that severely mentally ill people are being sentenced to death and executed. And the whole thing, as people learn more about it, we go back to that thing, the more you know about the death penalty, the less you like it. And in some counties in Florida, it was polled 3-1 in favor of, life over death.
And we just have one more question, which actually segues nicely, I think, into our final section. And that is, how can we stop the death penalty in Florida? What has worked in other states? So I don't know if maybe a couple of our panelists want to address that, but then Mark, I want you to address that finally.
I can say briefly about some other states. The state of Washington recently abolished, and it had a lot to do with a study that was done by a sociologist at the university there that showed the racial dynamics of the death penalty in Washington, in particular the race of the victims. In New Jersey, when they abolished, a lot of the argument had to do with the fact that they barely used the death penalty and that the cost was exorbitant, and that cost could be reallocated, that budget could be reallocated to cold cases or to some other criminal justice value. The state of New Jersey had actually executed, I think, just a single person in the entire history of their death penalty system. So, and the cost was in the hundreds of millions of dollars to impose the system statewide, with all the different trials that either led to a death sentence that was later overturned, or which was in any case never carried out. In the state of Illinois, it was abolished largely with concern about innocence, because there were terrible scandals in the Chicago Police Department leading to large numbers of people having been tortured and forced into false confessions that was brought to light. So in different states, it's been different arguments, sometimes race, sometimes capriciousness. In Virginia, which was, of course, the biggest death penalty state historically in the South, they abolished just in 2020 by action of the legislature signed by the governor, and it had a lot to do with race. And then another thing that a lot of states are paying attention to is the fact that the death penalty is slowly fading away. We're not using it very much, with regards to death sentences are not being imposed in high numbers anymore, or with regards to executions. They're not being used very often. So it's not a significant priority for the law enforcement community because they're not using it. It costs a lot. There's a danger of executing an innocent individual. And we know that there's terrible biases essentially towards any vulnerability, whether that vulnerability is race, mental illness, poverty, or something else. It's targeted on the most vulnerable. So I think all those arguments, different arguments find fertile ground in different legislatures, and different states have different kind of episodes that bring one or another argument to the forefront of the media. So there's a number of them, but it's never been, I don't think, a moral argument, a religious argument, because people don't move from their moral and religious positions. They start with those, and then they may learn about some facts they weren't aware of previously.
I would
And
say that-
go ahead.
I would also say that faith communities have been really important in some legislative movement against abolition. I think about Virginia, where there was kind of a big kind of interfaith coalition, and especially engaging with Black faith leaders, bring those kind of racial justice issues to the forefront. I think we're seeing some of the same in Ohio. So I do think that there's an important role to bring that moral voice, even if it's really a lot of the practical arguments and are really the ones that are carrying the day. But I think there's definitely a role here.
Let me agree with that. Also, the organizational capacity of the religious community can be very significant. And I would add the case of Connecticut to this, where there was a very significant movement of the religious communities that were traditionally against the death penalty, making a partnership with some racial justice organizations and civil rights organizations that really were able to mobilize large numbers of people into the anti-death penalty campaign in Connecticut, and successfully so.
I would just like to add to that, you know, I've seen great success. We have witnesses. It was part of Virginia legislation that we went and signed a bunch of death row exonerees up there to talk to the legislations, and down there in Colorado also. But I think the biggest thing that for me to see that is so great is that now they see not just one group of faith, but they see many different groups of faith pulling together in the communities and showing that they does not support the death penalty. And they also see that the people that is required to vote for them is not supporting the death penalty. So that gives them a little strength to actually move forward to try to agree and vote to abolish the death penalty in their state.
I'd just like to tag on real quick to everybody that I've heard. In states that have ended the death penalty, it's usually communication and organizing. It's bringing people together. It's communicating the different facts and the information about it. People that haven't been involved in the opposition, the active opposition to the death penalty, whether they're faith groups, whatever they are, it's bringing people together in an organized fashion, having a strategic plan that's well thought out, that is step by step. And that's something, by the way, we have spent a lot of time doing and have helped putting that together. FADP is organizing faith groups, communities of color, everybody that can come forward that maybe hasn't before, but now they are, and they're working as part of an organized network to bring the pressure to bear in the legislature and in the public to do away with this death penalty once and for all.
And can I'll also just say something from that kind of organizing perspective, not with my Death Penalty Information Center hat, but with my used to be at the National NAACP hat, and just looking at this racial justice moment. I think this is also a time that a lot of people in various movements are taking some internal work. People who have been working on issues that are related to racial justice forever, but are also in predominantly white spaces, to think through, what does implicit bias mean for me? How does implicit bias show up in our work? And actually doing some deep work internally to actually look at how they're actually making coalitions across racial lines and things like that. So I would just encourage folks, as if you're thinking about this from an organizing perspective, what like inner work can be done on those issues when we're looking at these racial justice issues and really going deeper, even for folks who have been doing this work for decades. I think they're coming to some great discoveries.
Love this. This could be a whole panel discussion and seminar in itself. Is how do we get there? I will say that all the signs are, all the momentum is for the end of the death penalty in Florida. We're very, close to what happens, and it's on the way out. It's creating that, that aha moment that this is ending, and bringing people together to work together to push it over the line and finally end this thing. So I've just got a few slides here to show. The first one is what's the current situation of the death penalty in Florida, as far as how does the program work? How does it make mistakes? So since the 1970s, 99 people have been put to death in Florida's death chamber. And since the 1970s, 30 people, innocent people, have been exonerated and released from death row here. So for every 3 executions, there's been 1 exoneration. And I have to say, if I was a staunch proponent, for whatever reasons, of the death penalty, and I found out there was 1 innocent person on death row, that would be it for me. I couldn't support a program, a government program that can make those kind of mistakes. It would be impossible. We've had 30 in Florida, 185 nationally, and the number goes up constantly. It's time for that to end. Now, so who are the exonerees in Florida? What do they have in common? Well, of the 30 people that have been exonerated, 22 are people of color. That's 3 out of 4. I think it's 73% exactly, but it's 3 out of 4 people who have been innocent people who have been wrongfully convicted and sent to death row are people of color. Is that an accident? Is it a coincidence? Is it a correlation? Or is it cause and effect? Does it go that far? And I'm just, everybody can make up their own mind about what they think it is, but it sure seems clear. Now, this slide I'd like to leave up. I'm not going to talk behind it. I just like for everyone to read this. This really goes to the heart of when we talk about the death penalty and the legacy of lynching. Okay, a little background here. This, the information we have is not just some opinion. It's based on the best data we can find, and that's what we want people to make their decisions based on. This information on the 4 youngest juveniles executed in Florida's electric chair were 16 years old. That comes from the Department of Corrections website. You can click on their page, death row, and they actually have the people listed and the dates, which they're also appear here. What they don't list and what they don't tell us is that all 4 children were Black. And Fortune Ferguson, when he was 13 years old, was arrested, tried, and convicted within 24 hours. All perfectly legal. But if that's not legalized lynching, that's it. What would be a 13-year-old in court and within 24 hours is arrested, tried, and convicted, and it wasn't even murder, and he was eventually executed at age 16. So that, every time I see that, it gives me goosebumps and fires me up. It's so obvious what the system is. This information, these graphics and so forth, are all sourced and cited, and you can find them on our website at www.fadp.org. You can download this. It makes a great handout or brochure. I would like to point out something too that really moved me. I have a friend, Derek Jameson, who lives not far from me here in Tampa, and he's he's black, and he was on death row in Ohio for 20 years. And during that time, he had 6 death warrants, 6 execution dates were set. The last one, he came within 3 hours of being executed. He had his last meal, he had all that kind of stuff, but it was halted at the last minute, and there was new evidence that they were, hearing and they were reviewing and all that. He ended up being exonerated. And he told me, he said, the death penalty is modern lynching. They took me to the tree 6 times. The death penalty is modern lynching. They took me to the tree 6 times. And that's from someone that went to the tree 6 times and lived to tell about it. So that was very compelling for me when he told me that. And I told him I was going to use it because it's just, anyway, that's a toughie. So we have to change the law. Dr. Martin Luther King, and when he was in the Birmingham jail, said that his letter from the Birmingham jail said that just because something is legal doesn't make it right. And he went on to say that everything that was done in Hitler's Germany was legal. So that's what we need to do, is change the law. I'm going to stop screen sharing, and we're going to go to a little different spot here. We're nearing the end of our presentation. So wonderful when people are really good at what they do. We're so fortunate. So this is our website, fadp.org. You can see this first element is a petition to end, to exempt people with severe mental illness from the death penalty. And the thing with this is that most people think that people who are dealing with severe or serious mental illness are exempt from the death penalty, they're also exempt from being executed. However, and it's supposed to be that way, the US Supreme Court has ruled that way, but states like Florida have found loopholes a way around it. So people with serious mental illness at the time of their crime are facing the death penalty and sentenced to death. And people that it seems obvious are seriously mentally ill are executed, and this continues to happen. So what this will do, this will end the death penalty in Florida for people with serious mental illness. This is being pushed and promoted by mental health organizations in Florida. There's a new coalition that's coming together, but this has a really good chance of passing. And because most people think this is already the way the law is, but it's not. It's just not. There's a laundry list of people who've been executed that were obviously and sometimes diagnosed as seriously mentally ill. You can also go to, so please take a moment and read this petition. If it's something you want to sign, please do. We need more signatures on this. This is how things, someone said, how do you get things done? This is the kind of action that gets things done, that gets attention and moves things in the right direction. We also encourage people to sign up for our newsletter and get information on actions and what's going on, events like this one, what's taking place where, and please take a moment and sign up. You won't be bombarded with emails, nothing like that. It's everything is things we think you should like to know. So that's important. My friend Chris told me recently, she said, one day we're going to live in a society that doesn't tell us that we should kill people who kill people to show that killing people is wrong. And our goal is to end the death penalty for us, for our children, for posterity once and for all, and get this behind us. It makes no sense. There's no redeeming virtue or value whatsoever in the death penalty. Believe me, I've spent years looking for it. There's nothing there. It's just like an old bad habit, especially in the old South, where it lingers on. So the time has come to end this. It's ending. It's going away. Like John Lewis said, if you see something, do something. Stand up, stand out, speak up, speak out. Join with others. If you belong to an organization, sign on to just that I support, our organization supports ending the death penalty. Do these things, join together, and that's how we're going to move this across the finish line and have a world here that is more humane and less violent. That's the only way it's going to happen. We ourselves need to be more humane and less violent. So I want to thank everyone for coming today. I learned a lot, and I hope you learn some things too, and have things you can share with your friends. There's going to be a recording of this. We'll put that out there so you can share it, and you can visit our website again, fadp.org. You can contact me, you can contact people and find out answers to things. I think we had some great questions today. Thank you. Thank you for that. That's how it starts.